Welcome to this practice question review for the Pennsylvania Real Estate Salesperson exam. We'll break down why the right answer holds up, why the others don't, and the concept behind each question. Today's questions on property ownership and land use cover property types and fixtures, legal descriptions and rights, zoning and police power, estates and ownership interests, deeds and title insurance. Right on our website, you'll find free practice questions and study guides created to help you master the Pennsylvania Real Estate Salesperson exam. Everything you need to succeed is right there waiting for you. Simply click the link in the description below to get started today, and remember, always study smarter, not harder as you prepare. Alright, let's get started. Question 1. A seller agrees to include the freestanding washer and dryer in a home sale. Which document transfers ownership of these movable items to the buyer? Your options are a general warranty deed, B, a quitclaim deed, C, a bill of sale, D, a addendum clause. Which one is it? Pause the video if you need more time. The correct answer is C, a bill of sale. C is correct because personal property such as a freestanding washer and dryer transfers by a bill of sale rather than by deed. The deed conveys the real estate, while movable chattels pass separately through the bill of sale. A is wrong because a general warranty deed conveys real estate along with the strong covenants of title that come with it. Movable appliances are not real estate, so a deed is the wrong instrument to pass them. B is wrong because a quitclaim deed releases whatever interest a person may hold in real property, with no warranties attached. It addresses clouds on land title and has no role in transferring household appliances. D is wrong because a addendum clause is the part of a deed that defines the estate the grantee receives. It is a clause within a conveyance, not a separate document that moves ownership of personal property. Property law splits everything into two categories, and figuring out which one an object belongs to decides which document transfers it. Real property is the land itself and anything permanently attached to it. Personal property or chattel is everything movable, like a freestanding appliance that simply plugs in and rolls away. A deed conveys real property and gets recorded in the county land records, so ownership of land can always be traced. A bill of sale conveys personal property and it never enters that public register. Picture a seller leaving a washer and dryer for the buyer. Neither is bolted down, so neither becomes a fixture. The deed conveys the house and lot, while a separate bill of sale names the appliances and transfers their ownership. The test is simple. Ask how the item would be classified the day before the sale. Land and attachments ride the deed. Movable goods need their own bill of sale. Question 2. A built-in dishwasher was once sold as an appliance but is now plumbed and wired into the kitchen. What has this item become through its attachment? Your options are a fixture, B, a trade fixture, C, an emblement, D, a chattel. Take a second. Which answer would you pick? The correct answer is A, a fixture. A is correct because an item that began as personal property but has been permanently attached to a building becomes a fixture and passes with the real estate. The dishwasher's plumbing and wiring show it is now realty. B is wrong because a trade fixture is something a tenant attaches to run a business and lease space. This dishwasher serves an ordinary household kitchen, not a commercial enterprise, so the trade fixture label does not fit. C is wrong because an emblement is an annually cultivated crop treated as the tenant farmer's personal property. The term belongs to agriculture and growing things, not to an appliance installed within the plumbing of a residence. D is wrong because a chattel is movable personal property that has not been affixed to land. Once the dishwasher was plumbed and wired in, it lost that movable character and crossed over into real property. A built-in dishwasher tells the whole story of a fixture in one life cycle. It starts as personal property on a store shelf, but once it's plumbed, wired, and secured into the cabinets, it converts into real property that passes with the house. Without a default rule, every home sale would turn into an argument over what stays and what goes. So the law presumes that anything annexed to the property conveys with it, while movable items leave with the seller, and anyone wanting a different outcome must say so in writing. Courts weigh 3 factors to decide if annexation happened: the method of attachment, whether something is bolted or wired in versus just hung on a nail; adaptation, whether it was custom fit for that space; and intention, the factor that carries the most weight, since attachment and adaptation are really just evidence pointing toward the party's intent. The dishwasher makes this concrete. Its plumbing and wiring are physical evidence of permanence, and its fitted place in the cabinet run shows adaptation to that kitchen. Both signs point the same direction, so it conveys with the house unless the seller excludes it in writing. A bolt is evidence, not the verdict. Classification can even reverse through agreement and severance. So remember, a fixture earns real estate status through permanent attachment and evident intention, and it stays with the land unless the parties carve it out. Question 3. A buyer and seller dispute whether a custom bookcase bolted into a wall alcove stays with the house. Which legal tests would a court apply to decide? Your options are: A. The 4 unities; B. The bundle of rights; C. The doctrine of escheat; D. The Maria test. Before I reveal it, which one do you think is right? The correct answer is D. The Maria test. D is correct because courts decide fixture questions with the Maria test, weighing method of attachment, adaptation, relationship of the parties, intention, and any agreement. A bookcase bolted into a fitted alcove satisfies attachment and adaptation, pointing toward a fixture. A is wrong because the 4 unities of possession, interest, time, and title govern whether a joint tenancy exists. They define a form of co-ownership and say nothing about when an attached object becomes part of the realty. B is wrong because the bundle of rights describes the separable ownership interest a property owner holds. It explains what an owner may do with land, not whether an installed item has converted into real estate. C is wrong because escheat is the state's power to take property when an owner dies without a will and without heirs. It concerns ownerless estates passing to government, far removed from a dispute over a built-in bookcase. When a buyer and seller can't agree whether something like a bookcase or heating unit stays with the house, courts don't just guess. They apply a 5-part test known by the acronym MARIA. Method of attachment asks how firmly the item is fixed and whether removing it causes damage. Adaptation asks whether the item was custom fitted to that specific property. Relationship of the parties tilts doubt toward buyers or tenants. Intention is what the objective facts show, and agreement is a written term that can override everything else. Picture a custom bookcase bolted into a fitted alcove in a house sale dispute. It's bolted in, satisfying method of attachment, and built specifically for that space, satisfying adaptation. With no contrary contract term and doubt favoring the buyer, every factor lines up. So the bookcase conveys with the house. The factors aren't weighted equally. A written agreement can end the analysis instantly, and absent one. Intention inferred from the objective facts does most of the real work, with method and adaptation simply serving as evidence of that intention. Fixture disputes are a structured reading of permanence, fitness, relationship, and above all intention, with a written agreement able to trump the rest whenever the parties bother to write one. Question 4. A restaurant tenant in Pittsburgh bolts a walk-in cooler and prep stations into leased space to run the business. How does the law classify this equipment? Your options are: A. Real property of the landlord. B. The tenant's trade fixtures. C. An appurtenance to the land. D. An emblement of the tenant. What's your answer? Commit to one before I continue. The correct answer is B. The tenant's trade fixtures. B is correct because equipment a commercial tenant installs to conduct business is a trade fixture and stays the tenant's personal property. The tenant may remove it on or before the lease ends, provided any damage from removal is repaired. A is wrong because ordinary fixtures attached by an owner become the landlord's realty, but trade fixtures are the recognized exception. Because a tenant installed this cooler for commerce, it does not pass to the landlord as real estate. C is wrong because an appurtenance is a right that runs with the land, such as an easement benefiting a parcel. Business equipment bolted in by a tenant is tangible personal property, not a right attached to the realty. D is wrong because emblements are annual crops a tenant cultivates and may harvest after the tenancy. The doctrine covers growing agricultural produce, so it cannot describe refrigeration and prep equipment installed inside a leased restaurant. Normally, anything bolted, wired, or plumbed into a building becomes part of the real estate. But the law carves out a major exception for business tenants, and that exception exists to protect commerce. A trade fixture is anything a commercial tenant attaches to leased space to carry on a trade. A walk-in cooler, salon chairs, shop shelving, bakery ovens, all are physically attached, yet all remain the tenant's personal property, because their purpose is the tenant's business, not the landlord's building. Picture the exact same walk-in cooler, bolted into the exact same floor. If the landlord installed it as a permanent upgrade, it's an ordinary fixture that belongs to the building. If a tenant installed it to run their restaurant, it's a trade fixture that belongs to the tenant. Attachment looks identical either way. The installer's identity and purpose is what flips the result. Exams love to crowd similar terms together. A trade fixture is business equipment installed by a tenant. An appurtenance is a right that runs with the land, like an easement, not a physical object at all. An emblement is simply an annual crop. Only the trade fixture carries a tenant's removal right. The tenant may remove trade fixtures up through the end of the lease, but must repair any damage left behind. Leave the equipment past the lease term though, and it can pass to the landlord as abandoned property. Question 5. A tenant farmer near Lancaster plants and tends a yearly corn crop, then the land is sold before harvest. What is the growing corn considered? Your options are A. The tenant's personal property. B. A fixture passing with title. C. Part of the real property. D. An appurtenance to the land. Pick one. Trust your gut. Here's your chance to test yourself. The correct answer is A. The tenant's personal property. A is correct because under the Emblements doctrine, an annually cultivated crop is the tenant farmer's personal property. The tenant keeps the right to re-enter and harvest that crop even after the land changes hands or the tenancy ends. B is wrong because a fixture is former personal property attached to a building so that it passes with the real estate. A seasonal corn crop is cultivated produce, not an object affixed to the structure or the land. C is wrong because naturally growing trees and perennials are real property, but cultivated annual crops are treated differently. The labor a tenant invests each season keeps the corn classified as personal property rather than realty. D is wrong because an appurtenance is a right that travels with the land to a new owner. Growing corn is tangible produce raised by the tenant's effort, not a legal right attached to and running with the parcel. Long before modern leases, the common law faced a fairness problem. A tenant plants and tends a crop all season, but the tenancy ends or the land sells before harvest. The doctrine of emblements grew up to make sure that tenant doesn't lose an entire season's labor to whoever holds title on harvest day. Emblements are the annually cultivated crops a tenant raises, like corn, wheat, and soybeans. Because the law treats them as the tenant's personal property rather than real estate, they don't automatically pass with the land, and the tenant's right to them survives a sale or the end of the tenancy. The mechanism is a right to re-enter and harvest, sometimes called the way-going crop right. If a tenancy ends through no fault of the tenant or the land changes hands, the tenant may come back onto the property to gather the crop planted while the tenancy was in force, though the right is narrow and tied only to that specific crop. Don't confuse emblements with fixtures. A fixture is personal property that became realty by attachment, like something screwed or wired into a building, while an emblement is a growing crop that stays personal property because of cultivation. They pull opposite kinds of things out of the ordinary real property presumption. Natural growth like trees and perennial grasses belongs to the land, but a season of planted labor belongs to the one who planted it. That fairness to the cultivator, protected only when the tenancy ends by surprise rather than by the tenant's own fault, is the whole reason the doctrine exists. Question 6. An owner leases a unit, grants a utility easement, and mortgages the property while keeping ownership. Which concept describes these separable interests an owner can divide? Your options are A. Status, B. Escheid, C. The bundle of legal rights, D. Adverse possession. Which would you go with? Lock it in before the reveal. The correct answer is C. The bundle of legal rights. C is correct because the bundle of legal rights describes ownership as a collection of separable interests, including possession, control, enjoyment, exclusion, and disposition. An owner may lease, encumber, or grant easements on individual rights while keeping the underlying title. A is wrong because situs refers to a location's desirability and the preference buyers show for one area over another. It helps explain value, but it does not describe the divisible ownership interests a property holder may separate. B is wrong because escheat is the government's power to take property when an owner dies with no will and no heirs. It addresses ownerless land passing to the state, not the rights an owner separates while alive. D is wrong because adverse possession lets a trespasser gain title through open, hostile, continuous use for the statutory period. It is a way ownership is lost, not a description of the separable interests an owner holds. Ownership of land isn't one indivisible thing. It's easier to understand as a bundle of separate rights that an owner holds all at once. The classic strands are possession, control, enjoyment, exclusion, and disposition. A fee simple owner holds every strand, while lesser interests hold only some. The reason this metaphor matters is that strands can be dealt out individually while the owner keeps the rest, which is what makes real estate such a flexible asset. Picture an owner who leases a unit to a tenant, grants a utility and easement across the yard, and takes out a mortgage with a lender. 3 strands go to 3 parties. Yet the owner still holds title and will recover the rest as the lease ends and the loan is paid. A lease, a mortgage, and an easement can all exist on one parcel at the same time without any contradiction. That's the bundle of legal rights. Ownership as many separable strands, not a single unbreakable whole. Question 7. 2 streets of nearly identical homes face each other across a river, yet one side commands higher prices. Which economic characteristic of land best explains this? Your options are A. Indestructibility, B. Immobility, C. Non-homogeneity, D. Area preference. Don't overthink it. Which one feels right? The correct answer is D. Area preference. D is correct because area preference, also called status, reflects people's preference for one location over another based on convenience, reputation, schools, and views. It is the economic characteristic that best explains why comparable homes sell for different prices. A is wrong because indestructibility means the land itself endures even when buildings decay or are demolished. It speaks to land's physical permanence, not to why buyers will pay more to sit on one side of a river. B is wrong because immobility is the physical fact that a parcel cannot be moved from its location. Examinations pair it with citers to trip candidates, but immobility does not by itself drive the price gap between the streets. C is wrong because non-homogeneity means no two parcels are exactly alike. While true of every lot, that uniqueness is a physical trait and does not capture the market preference that lifts one street's prices above the other. Two nearly identical houses can sell for very different prices, and the reason is rarely the buildings themselves. The force behind that gap is called situs, or area preference, the economic trait that captures how much people value one location over another. Land is described through two sets of traits. The physical characteristics are immobility, indestructibility, and non-homogeneity, while the economic characteristics are scarcity, improvement, permanence of investment, and area preference. Situs belongs to the economic set. It's not a fact about the dirt, but about how people value where that dirt sits. Picture two streets of comparable homes facing each other across a river. The structures are alike in size, age, and quality, yet one side consistently sells for more, because buyers prefer that side, whether for schools, views, or reputation. The homes are equal, the locations are not, and location is what the market is pricing. Examiners love pairing situs with immobility, but they're not the same. Immobility just means a parcel can't be relocated. Indestructibility means the land endures even as buildings decay. Only situs names the market's judgment that one spot is worth more than another. Immobility is about not moving. Situs is about being wanted. Buyers can renovate a house, add a room, or replace a roof, but they can't pick it up and set it in a better neighborhood. That's why, when a question holds the buildings equal and only the location changes, the trait being tested is situs, the price the market puts on being in one place rather than another. Question 8. A homeowner along a flowing stream near State College claims the right to reasonable use of the water passing the property. Which doctrine grants this right? Your options are A. Literal rights, B. Riparian rights, C. Prior appropriation, D. Police power. Got a guess? Lock it in. The correct answer is B. Riparian rights. B is correct because riparian rights belong to an owner whose land borders a flowing watercourse such as a river or stream. The owner has reasonable use of the water as it flows past, and these rights ordinarily pass with the land. A is wrong because literal rights apply to land bordering a static, navigable body of water like a lake or ocean. A flowing stream is not a static body, so the literal label does not match the facts described. C is wrong because prior appropriation governs water in arid states, where the government grants permits for beneficial use by priority date. Pennsylvania is a water-rich state that follows common law riparian rules instead of that permit system. D is wrong because police power is the government's authority to regulate land use for public welfare, such as zoning. It is a public regulatory power, not the private water right an owner holds along a flowing stream. Water rights all hinge on one question: is the water flowing or is it still? That single fact decides which legal doctrine applies to a piece of land. A riparian owner's land touches a flowing watercourse, and that owner may make reasonable use of the water as it passes by. Drawing water for a household or livestock is fine, but diverting or fouling the stream so neighbors lose their share is not. The right runs with the land, passing automatically to a new buyer when the property sells. Pennsylvania is water-rich, so it follows the common law riparian approach, letting everyone along the bank share what flows past. Arid western states can't share that way, so they use prior appropriation instead, where the government issues permits and priority runs by whoever claimed the water first. A homeowner along a moving stream near State College has riparian rights simply because the land touches flowing water. Change that stream to a lake, and the same land would instead carry littoral rights, since littoral rights attach to still, navigable water like a lake or ocean. Ask whether the water moves or sits, and whether the region is wet or arid, and the governing doctrine names itself. Also remember that riparian rights are a private entitlement from the land, entirely separate from the government's police power to zone or regulate. Question 9. A Pennsylvania deed conveys the surface to a buyer while the grantor keeps the gas and coal beneath. Which type of property right has been retained here? Your options are A. Subsurface rights, B. Air rights, C. Littoral rights, D. A license. Which one is it? Pause the video if you need more time. The correct answer is A. Subsurface rights. A is correct because subsurface rights cover the minerals, oil, gas, and coal lying below the surface, and they can be sold or reserved separately. Over the Marcellus Formation, Pennsylvania grantors commonly keep these rights while conveying the surface. B is wrong because air rights concern the use of the space above the surface, not the resources below it. Reserving gas and coal involves the layer beneath the ground, which is the opposite end of the three-dimensional parcel. C is wrong because littoral rights involve the use of water bordering a parcel along a lake or ocean. They have nothing to do with minerals beneath the soil that a grantor chooses to keep when selling the surface. D is wrong because a license is revocable permission to use another's land, not an ownership interest in resources. Retaining gas and coal is keeping a real property interest, far stronger than mere permission to enter the land. Land is not just a flat outline on a map. It is a vertical wedge running from the sky above down through the earth below, and ownership can be split along that vertical axis just like a horizontal boundary. Subsurface rights cover the minerals, oil, gas, and coal beneath the ground, and they can be treated as a distinct estate. A grantor can convey the surface while reserving what lies below, splitting one parcel into a surface estate and a mineral estate, each capable of separate ownership. Picture a single parcel sliced into layers, air rights above, the surface estate at ground level, and the subsurface estate below, where Pennsylvania's Marcellus Shale holds vast reserves of natural gas. A grantor can sell the surface for a home or farm while quietly keeping the gas and coal locked in the rock beneath. Once severed, the mineral estate can be sold, leased, inherited, and taxed independently of the surface, running as its own chain of title through entirely different owners over decades. That's what separates it from a mere license. A reserved mineral right is a durable ownership interest that doesn't evaporate just because the surface changes hands. A buyer who takes only the surface may later discover someone else owns the right to drill or mine below, a split estate hidden in the deed's reservations. The lasting lesson: surface ownership and mineral ownership are separate things, and holding one guarantees nothing about the other. Question 10. A river gradually deposits soil along a parcel's bank over many years, slowly enlarging the land. By what process does the owner gain this new ground? Your options are avulsion, B. reliction, C. accretion, D. erosion. Take a second. Which answer would you pick? The correct answer is C. accretion. Sir is correct because accretion is the gradual increase of land caused by water depositing soil over time. The new soil, called alluvion, belongs to the owner whose land it builds against. and the boundary moves slowly with the water. A is wrong because avulsion is the sudden loss or addition of land by a violent act of nature such as a flood. Because it happens abruptly, the boundary generally does not move, the opposite of the slow build-up. B is wrong because reliction is the gradual uncovering of land when a body of water permanently recedes. Here, the water is depositing soil rather than retreating, so the new ground arrives by a different natural process. D is wrong because erosion is the gradual wearing away of land by water, wind, or ice. It describes a loss of ground over time, the reverse of the slow gain the owner experiences along this riverbank. Water is always reshaping the land it touches, and real estate law has 4 precise terms for it. Understanding these terms means understanding 2 questions. Was the change gradual or sudden? And did the land grow or shrink? Accretion is the gradual increase of land as water deposits soil along a bank, grain by grain, over months and years. That new soil is called alluvion, and it belongs to the owner whose land it builds against. So the boundary quietly moves outward with the water. 3 siblings complete the picture. Avulsion is sudden, violent change, like a flood tearing away a bank, and because it happens all at once, the boundary stays put. Reliction is the gradual, permanent retreat of water exposing old bed, while erosion is the gradual wearing away of land, the mirror image of accretion. Picture a river slowly depositing soil along a parcel's edge over many years. The owner gains land by accretion. The fresh soil is the alluvion, and the boundary edges outward to follow it, unlike a sudden flood, which would leave the old boundary exactly where it was. The real test isn't whether land was gained or lost, but whether the change was gradual or sudden. Gradual processes, accretion, reliction, and erosion all move the boundary, while sudden avulsion leaves it fixed, no matter how much land changed hands. Question 11. A Pennsylvania deed traces the boundary by direction and distance from a fixed starting corner and returns to that corner. Which description method is being used? Your options are A. Lot and block, B. Rectangular survey, C. Air lot, D. metes and bounds. Before I reveal it, which one do you think is right? The correct answer is D. Metes and bounds. D is correct because metes and bounds traces a parcel's perimeter by course and distance from a point of beginning and must return to that point to close. It is the traditional method for Pennsylvania's older and rural parcels. A is wrong because lot and block describes platted property by its lot, number, block, and subdivision name on a recorded plat. It points to a recorded map rather than tracing directions and distances around the perimeter. B is wrong because the rectangular survey system uses principal meridians and baselines to grid land into townships and sections. Pennsylvania was never surveyed this way, so it does not appear on a genuine Pennsylvania deed. C is wrong because an air lot describes a volume of airspace by elevation, used for condominium units and air rights. It measures height above a datum rather than tracing a perimeter along the surface of the ground. A metes and bounds description reads like walking directions around the edge of a parcel, starting and ending at the same fixed point. Metes are the distances, the measured length of each line, while bounds are the directions, the bearings and features that set each course. Every description starts at a point of beginning and must close by returning to that same spot, or it fails to enclose a complete parcel. The method relies on monuments, fixed markers like a stream, a stone, or an iron pin that anchor each course to the real world. A surveyor can stand at the point of beginning and retrace every leg, bearing, and distance all the way around until the boundary closes. Compare this to lot and block, which points to a recorded plat map, the rectangular survey, which grids land into townships and sections but never reach Pennsylvania, and the air lot, which measures elevation for condominiums. Only meets and bounds actually walks the boundary itself. That is why meets and bounds fits Pennsylvania so well. It can wrap around any irregular shape a stream or ridge carves out, something a rigid grid never could. Question 12. In a meets and bounds description, a stated distance conflicts with the location of an iron pin set as a marker. As a rule of construction, which controls? Your options are A. The monument controls, B. The distance controls, C. The lower figure controls, D. The description is void. What's your answer? Commit to one before I continue. The correct answer is A. The monument controls. A is correct because when a fixed monument such as an iron pin conflicts with a stated distance, the monument generally controls. A marker physically on the ground was historically treated as more reliable than a measurement written on paper. B is wrong because treating the written distance as controlling reverses the traditional rule, because measurements can be miscopied while a planted marker stays put. Courts favor the monument when the two disagree in an older description. C is wrong because no rule of construction selects whichever number is smaller. Priority turns on the relative reliability of monuments, courses, and distances, not on choosing a lower figure between two conflicting measurements. D is wrong because a conflict between a monument and a distance does not, by itself, void the description. Courts resolve the inconsistency through established priority rules, preserving the conveyance rather than discarding it for a single discrepancy. Old land descriptions were handwritten and measured with chains that drifted, so conflicts were inevitable. When a written distance disagrees with a physical marker, the law has a clear tiebreaker: the monument controls. A monument is a fixed identifiable object marking a corner or line, while a distance is just a number on paper. When they conflict, the marker wins, because it can be seen and touched, whereas a written figure can be miscoppled or transposed as a deed is recopied across generations. This preference fits inside a larger priority ladder. Natural monuments rank first, then artificial monuments, then courses, then distances, and finally area or quantity. The more reliable and harder to fake an element is, the higher it ranks. Picture a boundary where a stated distance calls for one length, but the iron pin set as the corner sits elsewhere. The monument controls, so the boundary runs to the pin rather than to the theoretical measured point. There's no rule that the lower number wins, and a conflict never voids the deed. Courts simply apply the priority ladder. The whole system trusts what is hardest to falsify, from natural monuments down to computed area. Question 13. A developer records a plat dividing a tract into numbered lots and blocks in a county office. How may an individual parcel now be legally described? Your options are A. By township and range, B. By its mailing address, C. By lot, block, and subdivision, D. By tax parcel number. Pick one. Trust your gut. Here's your chance to test yourself. The correct answer is C. By lot, block, and subdivision. C is correct because once a subdivision plat is approved and recorded, each parcel can be described by its lot number, block, subdivision name, and county and state. The recorded plat supplies the precise detail, keeping the deed short. A is wrong because township and range belong to the rectangular survey system used in many western states. Pennsylvania was never surveyed under that grid, so this format does not describe lots in a recorded Pennsylvania subdivision. B is wrong because a mailing address identifies a property for deliveries but does not state boundaries and can change. It is never relied upon as the legal description because it cannot locate the precise edges of the parcel. D is wrong because a tax parcel number helps the assessor send a bill but does not define boundaries. Like a street address, it is an administrative label, not a legal description capable of locating the land. As towns grew and developers split large tracts into many small lots, tracing every boundary and every deed became clumsy. The lot and block system, also called the recorded plat system, solved that problem for good. The mechanism splits work between two documents. A surveyor prepares a plat with precise measurements, streets, and easements. The county records it as a permanent public reference, and the deed simply points to a lot, block, and subdivision name. Picture a developer recording a plat that divides a tract into numbered lots and blocks. Once recorded, any parcel can be described just by its lot, block, and subdivision name, with no bearings or distances needed in the deed itself. Examiners test whether you can spot a real legal description. A mailing address and a tax parcel number are only administrative labels. They state no boundaries, while a recorded plat and its lot and block reference actually locate the land. One regional trap remains. Township and range belongs to the rectangular survey system, a grid Pennsylvania never adopted. So when a Pennsylvania developer records a plat, the parcel is described by lot and block, never by township and range. Question 14. A buyer wants assurance that a new fence and driveway sit within the boundaries and reveal any encroachment before closing. Which professional service provides this? Your options are an appraisal, B, a survey, C, a home inspection, D, a title abstract. Which would you go with? Lock it in before the reveal. The correct answer is B, a survey. B is correct because a survey by a licensed surveyor locates a parcel's corners and improvements and confirms its boundaries on the ground. It reveals whether a fence or driveway encroaches across a line or violates a required setback. A is wrong because an appraisal estimates a property's market value for a lender or buyer. It analyzes comparable sales and condition rather than measuring boundaries, so it cannot confirm whether improvements cross a property line. C is wrong because a home inspection evaluates the condition of the structure and its systems. It looks at the roof, plumbing, and wiring, not the legal boundaries, so it would not disclose an encroachment over a line. D is wrong because a title abstract summarizes the recorded instruments affecting ownership. It reports liens and conveyances from the public record, but does not physically measure the land to show where a fence actually sits. A title search can tell a buyer who owns the land, but it can't tell them whether the new fence actually sits inside the property line. That question belongs to a different professional entirely, the surveyor. A licensed surveyor takes the legal description, whether meets and bounds or lot and block, and physically re-establishes the parcel's corners in the field. Then they measure exactly where structures, fences, and driveways actually fall in relation to those lines. Surveys exist to catch two specific problems: encroachments, where an improvement crosses the boundary line, and setback violations, where a structure sits closer to the line than zoning allows. Both are invisible on paper, but obvious once the ground is measured. An appraisal estimates market value, a home inspection checks the roof and systems, and a title abstract summarizes liens and ownership claims. None of them measure a boundary, which is exactly why a survey exists alongside them. A spotless title report can never reveal a garage sitting a foot over the line. Only a survey answers where the land is and whether the improvements respect its edges. Question 15. A condominium declaration fixes the floor and ceiling of each unit by elevation above a reference plane. What is that established plane of elevation called? Your options are A, a benchmark, B, a monument, C, a point of beginning, D, a datum. Don't overthink it, which one feels right. The correct answer is D, a datum. D is correct because a datum is an established plane of elevation, traditionally mean sea level, against which heights and depths are measured. Condominium declarations use it to fix each unit's airspace by floor and ceiling elevations. I is wrong because a benchmark is a permanent marker of known elevation tied back to the datum. It is a reference point used during surveying, not the underlying plane of elevation that the declaration measures from. B is wrong because a monument is a fixed marker such as an iron pin or stone used in a meets and bounds description. It marks horizontal boundaries on the surface, not the vertical reference plane for measuring airspace. C is wrong because a point of beginning is the fixed starting corner of a meets and bounds description. It anchors a perimeter traced across the surface, not the elevation plane used to describe a condominium unit's height. Legal descriptions map a parcel's outline well, but a condo unit floating on the third floor needs its position in the air described too. A datum is an established plane of elevation, traditionally mean sea level, from which all heights and depths are measured. Meets and bounds and lot and block locate a parcel across the surface, but they say nothing about elevation. A condominium declaration fixes each unit's floor and ceiling by their height, above the datum, carving the building's airspace into stacked, separately owned volumes. A benchmark is a permanent marker of no elevation whose height ties back to the datum, but the benchmark points to the datum, not the reverse. A monument and a point of beginning are markers used in meets and bounds descriptions, anchoring a horizontal perimeter, not a vertical measurement. Sort each term by dimension, the datum and its elevations run vertically, describing the up and down of airspace. Monuments and points of beginning run horizontally, anchoring surface parcels, while the benchmark simply bridges the two as a marked point tied back to the datum. When a question asks what plane a condominium declaration measures elevations from, the answer is the datum. Keep the family straight by sorting vertical from horizontal, and the confusion disappears. Question 16. A city enforces a zoning ordinance that reduces a vacant lot's value but leaves a reasonable use, without paying the owner. Which governmental power is this? Your options are A. Police power, B. Eminent domain, C. Taxation, D. A shade. Got a guess? Lock it in. The correct answer is A. Police power. A is correct because police power is the authority to regulate land use for public health, safety and general welfare, and it requires no compensation. A reasonable zoning restriction that leaves a viable use is a valid exercise of it. B is wrong because eminent domain is the power to take property for a public use, and it requires just compensation. Because the city merely regulated use without acquiring an interest, no taking and no payment obligation arose. C is wrong because taxation raises revenue by levying ad valorem charges against property. The ordinance here limits how the land may be used, rather than imposing a tax. So this power does not describe the action. D is wrong because escheat returns property to the state when an owner dies without a will and without heirs. It deals with ownerless estates, not with regulating the use of land that still has a living owner. Government holds 4 classic powers over private land, remembered by the word PEAT: police power, eminent domain, taxation, and escheat. Police power is the broadest of these, and it's the one that touches the most owners. Police power is the government's authority to regulate how land is used to protect public health, safety, morals, and general welfare. Zoning, building codes, and environmental rules all flow from it, and none of them require paying the affected owner. The limit on police power is reasonableness. A rule must serve a legitimate purpose and still leave the owner a viable use of the land. If it does, no compensation is owed, even if the value drops. But if a regulation wipes out all practical use, it crosses into a taking that demands payment, which is where eminent domain begins. The clearest tell distinguishing these powers is whether government acquired something or merely restricted something. Police power regulates land use while the owner keeps title and possession. Eminent domain actually takes property or an interest in it and must pay just compensation. Taxation raises revenue and escheat handles ownerless estates, so neither fits a reasonable regulation that reduces value while leaving a viable use. Of the four powers, police power touches the most owners and pays the fewest of them. When government restricts land use but takes nothing and pays nothing, that's police power at work. Question 17. A state highway department takes a strip of private land to widen a road and pays the owner fair market value. Which power is being exercised? Your options are A. Police power, B. Escheat, C. Eminent domain, D. Deed restriction. Which one is it? Pause the video if you need more time. The correct answer is C. Eminent domain. C is correct because eminent domain is the government's power to take private property for a public use upon payment of just compensation. Widening a public road is a public use, and the payment satisfies the compensation requirement. A is wrong because police power regulates land use for public welfare without paying the owner. Here the state actually acquires a strip of land and pays for it, which goes beyond mere regulation of how property is used. B is wrong because escheat transfers property to the state only when an owner dies, intestate with no heirs. The road project takes land from a living owner for a public purpose, a situation escheat does not cover. D is wrong because a deed restriction is a private limit on land use placed in a deed or declaration. The highway taking is a government action, not a privately imposed covenant controlling what an owner may build. The Fifth Amendment lets the government take private property, but only under strict conditions. That conditional power is called eminent domain, exercised through a court process known as condemnation. Two requirements sit at the center of this power. The taking must serve a public use and the owner must receive just compensation. Remove either one and the taking becomes unconstitutional or amounts to outright theft. Picture a highway department taking a strip of private land to widen a road, paying the owner fair market value in return. Widening the road satisfies public use, and the payment satisfies just compensation, together making the taking lawful. The clearest comparison is police power, which only restricts land use for public welfare and pays nothing because it takes no property. Escheat only applies when an owner dies without heirs, and a deed restriction is a private limit, not a government act at all. Only eminent domain acquires land and pays for it. Whenever you see the government acquiring property and paying for it, you're looking at eminent domain, with public use and just compensation riding along as its twin requirements. Question 18. An owner dies leaving no will and no locatable heirs, and the property has no rightful claimant. Under which power does the land pass to the state? Your options are A. Eminent domain, B. Escheat, C. Adverse possession, D. Police power. Take a second. Which answer would you pick? The correct answer is B. Escheat. B is correct because escheat is the power by which property reverts to the state when an owner dies intestate without heirs or abandons it. It ensures land never remains ownerless and provides an orderly transfer to the Commonwealth. A is wrong because eminent domain is the taking of property for a public use with just compensation. It applies to a living owner's land needed for public projects, not to an estate left with no heirs to claim it. C is wrong because adverse possession passes title to someone who occupies land openly and hostilely for the statutory period. It rewards a possessor's long use, which is unrelated to property left behind by an owner with no heirs. D is wrong because police power regulates land use for the public welfare without transferring ownership. It governs how land may be used, not where title goes when an owner dies without a will and without heirs. Land can never be allowed to sit ownerless, because that would freeze its title, halt its taxes, and leave no one accountable. Escheat is the legal backstop that guarantees every parcel always has an owner, even when a person dies with nothing left behind. Escheat only kicks in at the very end of the ownership chain. The law first searches for a will, then for heirs like a spouse, child, parent, or sibling. Only when that search comes up completely empty does the property revert to the state, in Pennsylvania, the Commonwealth. Picture the ownership chain as a search that moves outward from the deceased, through a will, then through relatives, until only the state remains standing to catch the title when no one else can. Escheat stands apart from the other ways title can move without a sale. Eminent domain takes from a living owner and pays for it. Adverse possession rewards long-term hostile use. Police power never transfers ownership at all. Escheat alone is triggered purely by death, no will and no heirs. Whenever you see that pile-up of facts, a death, no will and no heirs, the property drifts to the state, keeping the tax rolls intact and the title unbroken. Question 19. Government action permanently floods a parcel and destroys its use, but no formal condemnation was filed. What action may the owner bring to recover compensation? Your options are a petition action, B, a suit to quiet title, C, a variance request, D, inverse condemnation. Before I reveal it, which one do you think is right? The correct answer is D, inverse condemnation. D is correct because inverse condemnation lets an owner sue the government for compensation when its action effectively takes or destroys the use of property without a formal condemnation. Permanent flooding that ruins the parcel can amount to such a taking. A is wrong because a partition action is brought by co-owners to end their shared ownership by dividing or selling the property. It resolves disputes among owners and offers no remedy against a government taking that floods the land. B is wrong because a suit to quiet title resolves competing claims and clears clouds on ownership. It settles who holds title rather than forcing the government to pay for property it has effectively taken through flooding. C is wrong because a variance request asks a zoning board for relief from a strict ordinance because of hardship. It addresses land use regulation, not compensation for a government action that has destroyed the parcel's usefulness. Sometimes the government destroys a property's use without ever filing to take it. A flood ruins a parcel, or a regulation wipes out all practical use, and no compensation is offered. The owner's remedy is inverse condemnation, a lawsuit forcing the government to pay. Inverse condemnation reverses ordinary eminent domain. Normally the government initiates the action and pays for what it condemns. Here the government has already taken or ruined the property in practice, but filed nothing. So the owner must sue to compel the compensation the Constitution requires. Picture a public project that permanently floods a parcel and destroys its use, with no condemnation ever filed. The owner cannot force the water back, so through inverse condemnation the owner sues, proves the flooding amounts to a taking, and recovers compensation. The permanence and severity of the intrusion is what makes it compensable. Don't confuse this with similar sounding actions. A partition action divides property among co-owners. A quiet title suit settles who owns the land. A variance request asks for relief from a zoning ordinance. None of these force the government to pay for a taking it accomplished, in fact. When a stem describes a physical invasion or regulation destroying all practical use, with no condemnation ever filed, and asks how the owner recovers, it's inverse condemnation, the mirror image of eminent domain. Question 20. A service station lawfully operated for years. The new zoning barred such uses, yet the station is allowed to continue. What is this continued use called? Your options are A. A non-conforming use, B. A variance, C. Spot zoning, D. A conditional use. What's your answer? Commit to one before I continue. The correct answer is A. A non-conforming use. A is correct because a non-conforming use was lawful when established but no longer conforms to a later zoning change. It is usually grandfathered so it may continue, though it generally may not be expanded or rebuilt if destroyed. B is wrong because a variance is permission granted in advance to deviate from the ordinance because of a unique hardship. The station did not seek relief, it simply predates the new rule, which is a different situation entirely. C is wrong because spot zoning singles out one parcel for treatment inconsistent with the surrounding area and the plan and is generally illegal. The station's continued operation reflects a prior lawful use, not an improper rezoning. D is wrong because a conditional use is a use the ordinance expressly permits subject to meeting stated conditions. The station's use is no longer permitted at all and survives only because it lawfully existed before the change. When zoning changes, some existing properties no longer fit the new rules. Instead of forcing them to shut down overnight, the law lets them keep operating as a non-conforming use. Picture a gas station that operated lawfully for years. New zoning then bars gas stations in that district, yet it's allowed to keep running. That's grandfathering, protecting an owner's settled investment made in good faith. The identifying pattern is always the same order. Lawful use first, restrictive zoning second, continued operation grandfathered third. That timeline is how you spot a non-conforming use on an exam. The protection comes with tight limits. A non-conforming use generally can't be expanded, usually can't be rebuilt if destroyed by fire, and the right to continue is lost if the use is abandoned. Keep this distinct from a variance. Permission sought in advance for a unique hardship, a conditional use, allowed when stated conditions are met, and spot zoning. An illegal favor carved out for one parcel. A non-conforming use predates the rule and needed no permission at all. Question 21. An owner of an oddly shaped lot near Allentown cannot meet a setback and seeks permission to deviate because of that unique hardship. What is being requested? Your options are A. A non-conforming use, B. A buffer zone, C. A variance, D. A subordination. Pick one. Trust your gut. Here's your chance to test yourself. The correct answer is C. A variance. C is correct because a variance permits an owner to deviate from a strict zoning requirement because compliance would impose a genuine hardship unique to that parcel. An oddly shaped lot that cannot meet a setback is a classic basis for one. I is wrong because a non-conforming use is a use that lawfully predates a zoning change and is allowed to continue. The owner here is not continuing an old use but seeking relief from a dimensional rule for a new project. B is wrong because a buffer zone is a strip of land or landscaping that separates incompatible uses. It is a planning device between districts, not the relief an individual owner requests to build despite a setback hardship. D is wrong because subordination is an agreement that changes the priority of liens, so a senior lien yields to a junior one. It concerns financing and recorded claims, not permission to deviate from a zoning setback requirement. When a rule can't be met because of the land itself, the zoning board offers a targeted fix called a variance. Let's break down what makes it different from every other zoning term you might confuse it with. A variance is permission from the zoning board to depart from a strict rule. granted only when the ordinance creates a genuine hardship on that specific piece of land. It doesn't rezone anything, and every neighboring lot still plays by the original rules. A dimensional variance, sometimes called an area variance, relieves a physical requirement like a setback, height cap, or lot coverage limit. A use variance permits an entirely disallowed use and is far harder to win, since it edges toward rewriting the zoning map itself, though both demand proof of hardship. Picture the Allentown wedge lot. Its odd shape means the standard setback leaves almost no room to build, because that hardship comes from the ground itself, not from the owner's choices. The board can allow construction closer to the line while the setback rule stays fully intact everywhere else. Keep a variance separate from its lookalikes. A non-conforming use is just an old grandfathered use with no hardship application. A buffer zone is a planning strip between districts. And a subordination is purely a financing agreement about lien priority. And remember, a hardship the owner manufactured or a wish for bigger profits never qualifies. Question 22. A subdivision deed restriction limits lots to single-family homes, while zoning would allow duplexes. When a private restriction and zoning conflict, which governs? Your options are: A. Zoning always governs. B. The older rule governs. C. The buyer chooses. D. The more restrictive governs. Which would you go with? Lock it in before the reveal. The correct answer is D. The more restrictive governs. D is correct because when a private deed restriction and a public zoning ordinance both apply and conflict, the more restrictive of the two controls. Here the single-family covenant is tighter than the zoning, so the owner must obey the covenant. A is wrong because zoning does not automatically override a private covenant. Both limits coexist, and the owner must satisfy whichever imposes the stricter standard, which in this case is the recorded single-family restriction rather than the zoning. B is wrong because priority between a covenant and zoning does not turn on which came first. The governing rule is the stricter of the two, regardless of the order in which the restriction and the ordinance were adopted. C is wrong because a buyer cannot simply elect which limit to follow. The land is bound by both the recorded restriction and the ordinance, and compliance with the more demanding requirement is mandatory, not a matter of preference. Land can be restricted by two separate rules at once: public zoning and a private deed restriction. Most of the time they agree, but when they conflict, one simple principle decides the outcome. Zoning is a public limitation imposed by the government across a district, while a deed restriction or restrictive covenant is a private limitation written into the deed. Both run with the land and bind every future owner, and neither one automatically outranks the other. Think of zoning as setting a floor of public regulation. A private covenant can always demand more than that minimum, so the only way to obey both rules is to follow whichever one is stricter. Picture a lot where the recorded covenant allows only single-family homes, but the zoning would allow a duplex. Because the covenant is stricter, it controls, and the owner may build only a single-family home. Not because private beats public, and not because older beats newer, but because following the tighter rule is the only way to break neither limit. Question 23. A landlocked rear parcel reaches the public road only by a right-of-way across the neighboring front parcel. What describes the burdened front parcel? Your options are: A. The dominant tenement. B. The servient tenement. C. A license. D. An encroachment. Don't overthink it. Which one feels right? The correct answer is B. The servient tenement. B is correct because in an easement appurtenant, the servient tenement is the parcel burdened by the easement. Here the front lot the right-of-way crosses. The benefited landlocked rear parcel is the dominant tenement. A is wrong because the dominant tenement is the parcel that benefits from the easement, which is the landlocked rear lot. The front parcel is burdened rather than benefited, so calling it dominant reverses the two roles. C is wrong because a license is revocable personal permission to use land and is not an interest in land. A recorded right-of-way for access is a true easement that runs with the land, not a revocable license. D is wrong because an encroachment is an unauthorized intrusion of an improvement across a boundary. The right-of-way here is a lawful, granted easement, not a structure wrongfully extending onto a neighbor's property. Every easement appurtenant involves two parcels playing opposite roles. When land benefits, the other is burdened, and telling them apart is the key to getting these questions right. The dominant tenement holds the benefit and the servient tenement bears the burden. When either parcel sells, the easement runs with the land. The new dominant owner inherits the benefit, and the new servient owner takes it subject to the burden. Picture a rear parcel with no road frontage, landlocked, crossing a neighbor's land to reach the street. That rear parcel benefits, so it's dominant. The front parcel it crosses is burdened, so it's servient. A reliable memory hook, the servient parcel serves the other one, and the word itself carries the burden it names. Calling the front parcel dominant reverses the relationship and inverts the answer. A license is mere revocable permission, and an encroachment is an unauthorized intrusion. Neither is a true easement. The servient owner still possesses the land and can build, farm, or sell it, so long as the easement isn't obstructed. Question 24. A utility company holds a recorded right to run power lines across many owners' parcels and may transfer that right. Which interest does the company hold? Your options are a commercial easement in gross, B, a personal easement in gross, C, an easement by necessity, D, a license. Got a guess? Lock it in. The correct answer is A, a commercial easement in gross. A is correct because a commercial easement in gross benefits a business entity rather than a neighboring parcel, the classic example being a utility's right to run lines across many properties. It is assignable and may be transferred or inherited by the company. B is wrong because a personal easement in gross is held by an individual for personal use and generally ends at the holder's death. It is not assignable, unlike the transferable utility right described in this question. C is wrong because an easement by necessity arises when a parcel would otherwise be landlocked without access to a road. The utility easement serves the company's distribution network, not a particular parcel cut off from a public way. D is wrong because a license is revocable permission that creates no interest in land and cannot be freely transferred. A recorded utility easement is a durable property interest the company may assign, which a license could never be. Not every easement benefits neighboring land. Some benefit a person or a business instead, and these are called easements in gross. There's a burdened servient estate, but no benefited dominant estate. This category splits into two branches, and that split decides everything. Commercial easements in gross benefit a business, personal easements in gross benefit an individual, and the entire practical difference between them is transferability. A commercial easement in gross, like a utility's right to run power lines across many parcels, is treated as a business asset. It can be assigned, sold, or inherited along with the enterprise. A personal easement in gross, like a right to cross land to reach a fishing pond, is tied to one person and generally dies with them. Picture a utility company holding a recorded right to run power lines across many owners' parcels, because that benefit runs to the business and its network, not to a neighboring parcel or a single person. It's a commercial easement in gross, transferable if the utility sells to another provider. So remember, in gross means there's no dominant parcel, and whether the right is commercial or personal decides whether it can travel. A commercial easement in gross is a transferable asset that outlives its holder. A personal one is a dead-end permission that expires with them. Question 25. A deed conveys land to a buyer with no conditions, granting the most complete ownership the law allows, lasting forever and freely inheritable. Which estate is this? Your options are A. A life estate, B. A leasehold estate, C. Fee simple absolute, D. Fee simple determinable. Which one is it? Pause the video if you need more time. The correct answer is C. Fee simple absolute. C is correct because fee simple absolute is the highest and most complete form of ownership. It is perpetual, fully inheritable, and carries the entire bundle of rights, limited only by the public and private restrictions that apply to all land. A is wrong because a life estate lasts only for the duration of a measuring life and then ends. Because it expires and cannot continue forever, it is a lesser estate than the perpetual ownership described here. B is wrong because a leasehold estate gives a tenant possession for a set time while the landlord keeps ownership. It is the estate of a renter, not the complete and perpetual ownership a fee simple absolute provides. D is wrong because fee simple determinable is ownership that ends automatically if a stated condition fails. The conveyance described carries no such condition, so the buyer receives an absolute fee rather than a defeasible one. Estates in land form a hierarchy, from the thinnest possessory interest up to the fullest ownership the law recognizes. At the very top sits fee simple absolute, the benchmark every lesser estate is measured against. This estate has no expiration and no condition that can cut it short. It lasts forever, passes freely to heirs, and can be sold, leased, mortgaged, or given away, containing the entire bundle of ownership rights. Calling it absolute doesn't mean it flows beyond all limits. Every parcel, even fee simple absolute, stays subject to 4 public powers: police power, eminent domain, taxation, and escheat, plus any recorded covenants. The word that separates the top estate from every rival is unconditional. A life estate is limited by a measuring life, a leasehold by a term and the landlord's retained title, and a determinable fee by a condition that can end it automatically. When a buyer purchases a home, they expect fee simple absolute, because anything less carries a catch that shrinks value. Ownership that is complete, perpetual, freely inheritable, and free of any condition is fee simple absolute. Question 26. A grantor deeds land to a church so long as it is used for worship, with title returning automatically if that use ever ends. Which estate results? Your options are A. Fee simple subject to conditions subsequent, B. A life estate, C. A leasehold estate, D. Fee simple determinable. Take a second. Which answer would you pick? The correct answer is D. Fee simple determinable. D is correct because durational language such as so long as creates a fee simple determinable, which ends automatically if the stated condition fails. The grantor keeps a possibility of reverter and title returns without any court action. A is wrong because a fee simple subject to a condition subsequent uses conditional words like on condition that and does not end automatically. The grantor would have to go to court to exercise a right of re-entry, unlike the automatic return described. B is wrong because a life estate is measured by someone's lifetime, not by how the property is used. Because the church's estate ends based on a use condition rather than a person's death, the life estate label does not fit. C is wrong because a leasehold estate gives temporary possession to a tenant under a lease. The church receives ownership that could last forever if the condition holds, which is a defeasible fee rather than a tenancy. A few words in a deed can quietly turn full ownership into an estate that can end on its own. Durational language like so long as, until, or while creates a fee simple determinable, a defeasible fee that terminates automatically the instant its condition fails. The defining feature is that word automatic, and it flows entirely from the durational phrasing, so long as, until, while, and during signal an estate that lasts only as long as something stays true. And when that condition breaks, title revests in the grantor with no court proceeding at all. Picture a grantor deeding land to a church so long as it's used for worship. If the congregation ever stops using it that way, ownership reverts to the grantor automatically, the instant the condition fails, with no legal action needed to reclaim it. The estate it's constantly confused with is the fee simple subject to a condition subsequent, which uses conditional phrasing like on condition that or provided that, and requires the grantor to affirmatively exercise a right of re-entry, usually in court. Durational words plus automatic reverter mean determinable. Conditional words plus an exercise right of re-entry mean condition subsequent. Grantors use a determinable fee to keep a hand on how land is used long after giving it away, tying a genuine gift to a purpose that can last forever. The possibility of reverter is the leash. The day the land strays from that purpose is the day it comes home. Question 27. A deed gives property to a person for the duration of her natural life, with no one named to take it afterward. What interest does the grantor retain? Your options are A reversion, B, a remainder, C, a possibility of reverter, D, a right of re-entry. Before I reveal it, which one do you think is right? The correct answer is A reversion. A is correct because when a life estate is created and no remainder man is named, the grantor keeps a reversion. The property returns to the grantor or the grantor's heirs once the measuring life ends and the life estate closes. B is wrong because a remainder is the future interest held by a named third party who takes when the life estate ends. Because no one was named to receive the property afterward, no remainder exists in this conveyance. C is wrong because a possibility of reverter follows a fee simple determinable and takes effect if a use condition fails. This conveyance creates a life estate measured by a lifetime, not a defeasible fee tied to a condition. D is wrong because a right of re-entry follows a fee simple subject to a condition subsequent and requires court action. The deed here grants a life estate, so the grantor's future interest is a reversion rather than a right of re-entry. When a grantor hands over a smaller estate and names no one to take it afterward, the law doesn't leave a gap. The leftover interest snaps back to the grantor automatically, and that retained interest is called a reversion. A reversion arises whenever a grantor conveys less than the full estate and leaves the leftover unassigned. It's vested the entire time, inheritable, and needs no court action to take effect once the lesser estate ends. Picture an owner in fee, simple granting a life estate to someone, with no one named to take it after. The life tenant holds and uses the land during the measuring life, while the grantor quietly holds the reversion, waiting for that life to end. Don't confuse this with its lookalikes. A remainder goes to a named third party. A possibility of reverter follows a fee simple determinable, and a right of re-entry follows a condition subsequent requiring court action, none of which apply to a plain life estate. The tell is simple, a lesser estate granted paired with silence about who comes next. The law feels that silence by sending the property straight back to the grantor. Question 28. A life tenant lets the roof fail and the structure deteriorate, reducing the value the future holder will receive. Which duty has the life tenant violated? Your options are A, the covenant of seisin, B, the duty of subordination, C, the duty against waste, D, the rule against perpetuities. What's your answer? Commit to one before I continue. The correct answer is C, the duty against waste. C is correct because a life tenant owes the future interest holders a duty not to commit waste. The life tenant must avoid damaging the property or unreasonably impairing its value, pay ordinary expenses, and keep the property reasonably maintained. A is wrong because the covenant of cession is a deed warranty that the grantor owns the property and may convey it. It concerns promises made in a deed, not a life tenant's obligation to preserve the property for the remainder man. B is wrong because subordination is an agreement that rearranges lien priority between lenders. It belongs to financing, not to the relationship between a life tenant and the future holder regarding upkeep of the property. D is wrong because the rule against perpetuities limits how long a future interest may remain unvested. It governs the timing of contingent interest, not a life tenant's day-to-day duty to maintain the home in sound condition. A life estate splits one property across time between two parties whose interests naturally pull against each other. The life tenant who holds and uses it now, and the future interest holder, a remainderman or reversioner who waits to receive it later. The duty against waste requires a life tenant to preserve the property for whoever takes it next. The life tenant may enjoy the property's ordinary benefits, but must also pay the ordinary carrying cost, like taxes and mortgage interest, and keep the property in reasonable repair. Waste takes more than one form. Voluntary waste is affirmative destruction, like stripping timber for profit. Permissive waste is damage through neglect, like a failing roof. Ameliorating waste raises value but changes the property's character without permission, and all three breach the duty. Picture a life tenant who lets the roof fail and allows the structure to deteriorate, steadily reducing the value the future holder will eventually receive. That is permissive waste, a breach through neglect rather than active destruction. A life tenant may possess, use, and profit from the property for the whole measuring life. But the duty against waste marks the outer edge of that right, the point where present enjoyment starts consuming what belongs to someone else. Question 29. Pennsylvania abolished common law dower and courtesy and instead lets a surviving spouse claim a fixed fraction of the deceased spouse's estate. What is this right called? Your options are A. A homestead life estate, B. The elective share, C. A reversion, D. Community property. Pick one. Trust your gut. Here's your chance to test yourself. The correct answer is B, the elective share. B is correct because Pennsylvania replaced dower and courtesy with a statutory elective share, letting a surviving spouse choose a fixed fraction of the deceased spouse's estate instead of what the will provides. The Pennsylvania elective share is 1/3. A is wrong because a homestead life estate shields the family home from certain creditors in some states. Pennsylvania does not provide that protection. Its homestead exclusion is only a property tax reduction, not a life estate for the survivor. C is wrong because a reversion is the grantor's future interest after a life estate with no remainder man. It is a land conveyancing concept, not the statutory share a surviving spouse may elect from a deceased spouse's estate. D is wrong because community property is a marital ownership system in 9 states where spouses equally own property acquired during marriage. Pennsylvania is not a community property state, so this does not describe the surviving spouse's right. For centuries, common law protected widows and widowers through dower and courtesy, life interest in a dead spouse's land. Pennsylvania abolished both as ill-suited to modern estates of stocks and bank accounts, replacing them with a modern tool, the statutory elective share. The elective share lets a surviving spouse reject the will and instead claim a fixed statutory fraction, 1/3 in Pennsylvania, The survivor weighs the will against that 1/3 and elects whichever is better. But the right must be exercised in time or it's lost. 3 competing terms each miss the mark. A homestead life estate isn't recognized in Pennsylvania, which only offers a small property tax break. A reversion is a grantor's future land interest, unrelated to spousal rights. And community property is a marital ownership system used in 9 other states, not Pennsylvania. The real lesson is about ownership. In community property states, most marital assets are owned equally by both spouses from the start. So a survivor already owns half. Pennsylvania is a separate property state, where each spouse owns what's titled to them, and the elective share is what keeps that system from leaving a survivor with nothing. So whenever a question describes Pennsylvania abolishing dower and courtesy in favor of a guaranteed statutory fraction, the answer is the elective share, set at 1/3 of the estate. Question 30. 2 unmarried friends take title together without stating any form, each holding an undivided share that passes to heirs at death. Which co-ownership form is presumed? Your options are A. Joint tenancy, B. Tenancy by the entirety, C. Ownership in severalty, D. Tenancy in common. Which would you go with? Lock it in before the reveal. The correct answer is D. Tenancy in common. D is correct because tenancy in common is the default form when co-owners take title without specifying otherwise. Each holds an undivided, possibly unequal share with no survivorship, and at death that share passes to the owner's heirs. A is wrong because joint tenancy requires express words of survivorship and the 4 unities, and it is not presumed. Without clear intent to create survivorship, the law defaults to a tenancy in common for the 2 friends. B is wrong because tenancy by the entirety is available only to a married couple treated as one legal entity. Because the 2 are unmarried friends, this form cannot apply regardless of how they take title. C is wrong because ownership in severalty is ownership by a single person or entity alone. Here 2 people share title together, so the property is co-owned rather than held in severalty by one owner. When co-owners take title together and say nothing about the form of ownership, the law can't leave the arrangement undefined. It fills that silence with the default tenancy in common. Each co-tenant holds an undivided fractional interest in the whole property, and shares need not be equal. The one thing every tenancy in common must have is unity of possession, but the feature that truly defines it is the absence of survivorship. Undivided means no co-tenant owns a specific physical piece of the land. Instead, each has the right to possess and use the entire property, subject to the equal rights of the others. The forms tested against tenancy in common each require something plain co-ownership lacks. Joint tenancy demands express survivorship language and the 4 unities. Tenancy by the entirety is reserved for married couples, and severalty is ownership by just one person alone. Survivorship strips a deceased owner's heirs of their inheritance, so the law refuses to presume it without clear intent. Absent that intent, co-owners are tenants in common, and their shares descend to their heirs. Question 31. 3 people hold title as joint tenants with right of survivorship. When one of them dies, what happens to that deceased owner's interest? Your options are A. It passes to the surviving joint tenants. B. It passes to the deceased's heirs. C. It escheats to the state. D. It becomes a life estate. Don't overthink it. Which one feels right? The correct answer is A. It passes to the surviving joint tenants. A is correct because the defining feature of joint tenancy is the right of survivorship. When one joint tenant dies, that interest passes automatically to the surviving joint tenants, outside the will and outside probate, until one survivor may hold the whole. B is wrong because passing to the deceased's heirs describes a tenancy in common, which has no survivorship. In a joint tenancy, the survivorship feature defeats inheritance, so the interest does not go to the deceased owner's heirs. C is wrong because escheat occurs only when an owner dies with no will and no heirs at all. Here, surviving joint tenants exist and automatically take the interest, so the property does not pass to the state. D is wrong because a life estate is an ownership interest measured by a lifetime, not a result of one joint tenant's death. Survivorship simply shifts the deceased's share to the survivors. It does not create a life estate. One feature separates joint tenancy from every other form of co-ownership, the right of survivorship. When a joint tenant dies, that share doesn't go to heirs or through probate. It automatically shifts to the surviving co-owners. Joint tenancy requires 4 unities: possession, interest, time, and title. These 4 unities exist for one reason out: to support survivorship. Picture 3 people holding title as joint tenants. When one dies, that owner's interest is simply extinguished, and the 2 survivors' shares enlarge to absorb it. No probate, no heirs, just an automatic shift to those who remain. Contrast this with tenancy in common, where a deceased owner's share passes to their heirs instead. And rule out 2 lookalikes. Escheat only applies when there are no heirs at all. And survivorship never creates a new life estate. It just enlarges the survivor's existing shares. In a joint tenancy, death sends the deceased owner's share straight to the surviving co-owners, automatically and outside of probate. That automatic transfer is the whole reason people choose joint tenancy in the first place. Question 32. A married couple in Pennsylvania takes title to their home together without specifying a form. Which co-ownership is presumed, shielding the home from one spouse's individual creditors? Your options are A. Tenancy in common, B. Community property, C. Tenancy by the entirety, D. Joint venture. Got a guess? Lock it in. The correct answer is C. Tenancy by the entirety. C is correct because Pennsylvania presumes a tenancy by the entirety for a married couple. It carries the right of survivorship, requires both spouses to sign to sell or mortgage, and shields the property from the individual creditors of one spouse. A is wrong because tenancy in common is the default for unmarried co-owners and offers no creditor protection or survivorship. Pennsylvania instead presumes entirety's ownership for spouses, so this default does not apply to the married couple. B is wrong because community property is a marital system used in 9 states, and Pennsylvania is not one of them. The couple's protection comes from tenancy by the entirety, not from a community property regime. D is wrong because a joint venture is a business arrangement formed to carry out a single project. It is an entity device for investors, not the form in which a married couple presumptively holds their family residence. Pennsylvania gives married couples a special form of co-ownership, built on the old idea that husband and wife are treated as one legal person. It's called tenancy by the entirety, and it's the default whenever a married couple takes title together without saying otherwise. Because the couple is legally one owner, neither spouse can sell, mortgage, or partition alone. When one spouse dies, the survivor automatically owns the whole property. And critically, this unity creates a shield against the individual creditors of just one spouse. A creditor chasing only one spouse's personal debt cannot touch the home, because neither spouse owns a separate piece of it to seize. Only a debt owed by both spouses together can reach the property. Tenancy in common is the default for unmarried co-owners and offers no survivorship or creditor protection. Community property is a marital system used in 9 states, but Pennsylvania isn't one of them. A joint venture is just a business arrangement for a project, not how spouses hold a family home. Whenever a married Pennsylvania couple holds a home together with no form specified, especially with creditor protection in play? The answer is tenancy by the entirety. Question 33. A cooperative resident receives shares in the corporation that owns the building plus a proprietary lease to occupy a unit. How is this ownership interest classified? Your options are A. Real property, B. A fee simple in the unit, C. A tenancy by the entirety, D. Personal property. Which one is it? Pause the video if you need more time. The correct answer is D. Personal property. D is correct because a cooperative owner holds stock in the corporation that owns the building plus a proprietary lease, not title to real estate. Because the interest consists of shares and a lease, it is classified as personal property. Is wrong because calling the interest real property describes a condominium, not a cooperative. A co-op owner holds corporate stock and a lease rather than a deeded estate, which keeps the interest in the personal property category. B is wrong because a fee simple in the unit is what a condominium owner holds with a deed to the individual unit. A cooperative owner has no deeded unit. The corporation owns the building and the resident owns shares. C is wrong because tenancy by the entirety is a married couple's form of co-owning real estate. It describes how title may be held, not the personal property nature of stock and a proprietary lease in a cooperative. Here is a fact that surprises many buyers. A cooperative apartment owner does not own real estate at all. They own corporate stock and a lease, and the law calls that personal property, not realty. In a cooperative, one corporation owns the entire building and the land beneath it. A resident buys shares reflecting their unit's value, and alongside those shares comes a proprietary lease, the contract granting the right to occupy a specific apartment. Picture the corporation sitting atop the entire building and land, holding real title to everything. The resident connects to it through two threads, shares of stock and a proprietary lease, gaining occupancy of a unit without ever owning a piece of the ground. The contrast that clarifies everything is the condominium. A condo owner receives a deed and owns real property outright, while a co-op owner receives no deed at all, only stock and a lease, making it personal property despite looking identical from the hallway. When a question describes a resident holding shares in the building's corporation, plus a lease to occupy a unit, classify that interest as personal property, because they own a piece of the company and a right to live there, not a piece of the ground. Question 34. A condominium buyer receives a deed to the individual unit together with an undivided interest in the hallways, roof, and grounds. How is that shared interest held? Your options are A. In severalty, B. As a tenant in common, C. As a proprietary lease, D. As a leasehold estate. Take a second. Which answer would you pick? The correct answer is B. As a tenant in common. B is correct because a condominium owner holds fee title to the unit plus an undivided interest in the common elements as a tenant in common with the other owners. The common areas are shared while each unit is separately deeded. A is wrong because ownership in severalty means a single owner holds the entire interest alone. The common elements of a condominium are shared among all unit owners, so they cannot be held in severalty by one buyer. C is wrong because a proprietary lease is the occupancy right a cooperative shareholder receives. Condominium common elements are owned outright as a tenancy and common share, not occupied under a lease from a corporation. D is wrong because a leasehold estate gives a tenant temporary possession under a lease. The condominium owner owns the common elements as part of the fee, not merely possesses them for a term as a tenant would. A condominium owner actually holds two distinct interests at the same time, and understanding both is the key to this topic. First, The owner has fee simple title to their individual unit. The airspace and interior bounded by its walls, floor and ceiling. Second, they hold an undivided share in the common elements, the hallways, roof, elevators and grounds, as a tenant in common with every other unit owner. Picture the building itself. One deeded unit belongs to a single owner outright, while the hallways, roof, elevators and grounds surround it as common elements shared among all the owners. Severalty means one owner alone, which cannot describe shared common elements. A proprietary lease belongs to a cooperative shareholder, not a condominium owner, and a leasehold only grants temporary possession, while the condo owner holds the common elements as part of the fee itself. Keep the pairing straight: fee title to the unit held alone, and an undivided tenancy and common share in the common elements held together with everyone else. Question 35. A tenant signs a lease for a fixed 2-year term with a stated beginning and ending date. Which leasehold estate has been created? Your options are A. An estate for years, B. A periodic estate, C. An estate at will, D. An estate at sufferance. Before I reveal it, which one do you think is right? The correct answer is A. An estate for years. A is correct because an estate for years is a lease for a definite, fixed term with specific beginning and ending dates. It does not automatically renew, needs no notice to terminate, and survives the death of either party or a sale. B is wrong because a periodic estate runs for recurring intervals, such as month to month, and renews automatically until proper notice. The fixed 2-year term with set dates here does not renew, so it is not periodic. C is wrong because an estate at will continues only by the ongoing consent of both parties and has no fixed term. The lease described has a definite term, which is the opposite of the indefinite duration of a tenancy at will. D is wrong because an estate at sufferance arises when a tenant wrongfully holds over after a lease ends. It describes an improper holdover, not a tenant lawfully occupying under a defined 2-year term. Let's dig into the estate for years. The leasehold defined not by its length, but by having certain fixed dates. The defining trait is a term certain. Both parties know the exact start and end dates from the outset. Because of that certainty, the lease simply expires on its own with no renewal, and no notice to terminate is ever needed. This fixed lease is remarkably durable. It survives the death of either the landlord or tenant passing to their estate, and it survives the sale of the property, binding the new owner for whatever term remains. Compare this against the other leasehold estates. The periodic estate renews automatically in intervals until notice is given. The estate at will runs only on ongoing mutual consent with no fixed term, and the estate at sufferance is simply a tenant wrongfully holding over. Whatever the length between them, a definite start date and a definite end date is always the signature of the estate for years. Question 36. A residential tenant pays a flat monthly rent while the landlord pays the property taxes, insurance and maintenance. Which type of lease is this? Your options are A. A net lease, B. A percentage lease, C. A ground lease, D. A gross lease. What's your answer? Commit to one before I continue. The correct answer is D. A gross lease. D is correct because under a gross lease, the tenant pays a flat rent and the landlord pays the operating expenses such as taxes, insurance and maintenance. This is the typical structure for a residential lease. A is wrong because a net lease shifts some or all operating expenses to the tenant in addition to base rent. Because the landlord here pays the taxes, insurance and maintenance, the arrangement is gross rather than net. B is wrong because a percentage lease adds rent based on the tenant's gross sales and is standard in retail. A residential tenant paying a flat amount has no sales-based component, so this lease is not a percentage lease. C is wrong because a ground lease is a long-term lease of land only on which the tenant builds improvements. The residential tenant here rents a finished dwelling with expenses covered, not bare land for development. Every lease has to answer one money question beyond the rent. Who covers the taxes, insurance, and maintenance on the property? Under a gross lease, the tenant pays a flat fixed rent, and the landlord pays the operating expenses out of that rent. The tenant gets a single predictable number each month, while the landlord absorbs the variable cost of ownership. Picture a residential tenant handing over one fixed rent check, while the landlord uses that money to cover property taxes, insurance, and maintenance. The tenant's exposure is capped at the rent. The landlord carries the fluctuating costs. The net lease is the gross lease's opposite. The tenant pays base rent plus some or all operating expenses, which is why net leases dominate commercial real estate. A percentage lease adds rent tied to sales, common in retail, and a ground lease covers long-term rental of bare land for the tenant to build on. The way to keep these straight is to ask who carries the operating expenses. A flat rent apartment where the landlord covers taxes, insurance, and maintenance is the simplest and most common structure, the gross lease. Question 37. A tenant remains in possession after the lease term ends, without the landlord's consent and against the landlord's wishes. Which estate does the holdover tenant hold? Your options are A. An estate for years, B. A periodic estate, C. An estate at sufferance, D. A fee simple estate. Pick one. Trust your gut. Here's your chance to test yourself. The correct answer is C. An estate at sufferance. C is correct because an estate at sufferance arises when a tenant who lawfully took possession holds over wrongfully after the lease ends without the landlord's consent. It is the lowest estate and the holdover is little better than a trespasser. A is wrong because an estate for years is a tenancy for a definite term that simply ends on a stated date. Once that term expired and the tenant stayed without consent, the estate for years no longer describes the occupancy. B is wrong because a periodic estate would arise only if the landlord accepted continued rent, converting the holdover into a renewing tenancy. Because the landlord objects, the wrongful holdover remains a tenancy at sufferance instead. D is wrong because a fee simple estate is full ownership, not a tenant's interest at all. A holdover tenant possesses nothing approaching ownership, so the fee simple label cannot apply to the situation. When a lease ends and the tenant refuses to leave, the law recognizes a strange, low-level status, the estate at sufferance. It requires lawful entry under a valid lease, a wrongful holdover after that lease ends, and no landlord consent to the continued stay. That lawful origin is what separates a tenant at sufferance from a true trespasser, even though the possession is now wrongful. Think of it like a guest who came in through the front door but refuses to leave once the party's over. The lawful entry is what keeps them a notch above a stranger who broke in, even though they now have no right to remain. An estate for years ends on its stated date and no longer applies once the tenant overstays. A periodic estate would arise only if the landlord accepted rent. A fee simple is full ownership, the opposite of a holdover is near nothing. Only the estate at sufferance fits an objecting landlord and a lingering tenant. An estate at sufferance is what a lawful tenancy decays into when the tenant overstays and the landlord withholds consent. One step above trespass, and a single acceptance of rent would quietly transform it into something more. Question 38. At a foreclosure sale, several liens compete for the proceeds. Which lien is paid first, regardless of when it was recorded against the property? Your options are A. A real estate tax lien, B. The first mortgage, C. A recorded judgment lien. D. A second mortgage. Which would you go with? Lock it in before the reveal. The correct answer is A. A real estate tax lien. A is correct because real estate tax and special assessment liens take priority over all other liens regardless of recording date. Government is paid first, so unpaid property taxes are satisfied ahead of even a first mortgage recorded years earlier. B is wrong because a first mortgage usually outranks later private liens under first in time, first in right. Even so, it yields to real estate tax liens, which jump ahead of all other claims no matter when they arose. C is wrong because a recorded judgment lien takes its place by recording date among ordinary liens. It does not enjoy the special priority that tax liens hold, so it is not paid ahead of the unpaid property taxes. D is wrong because a second mortgage is junior to the first mortgage and to tax liens. Its later position in the order of payment means it is among the last, satisfied, not the first. From the foreclosure proceeds, liens usually rank by first in time, first in right. Whichever is recorded earliest gets paid first when a property is foreclosed. But there's one giant exception that flips the whole line. Real estate tax and special assessment liens automatically outrank every other lien, no matter when they were recorded. The reasoning is that the public's claim to taxes is superior to any private lender's choice to record a mortgage. So the law puts government first, always. Picture a foreclosure sale. The tax lien is paid first, no matter its recording date. Only after the government is satisfied do the first mortgage, the judgment line, and the second mortgage line up behind it by their own recording dates. Among themselves, private liens still follow the ordinary rule. A first mortgage usually beats later liens. A judgment lien takes its place by recording dates, and a second mortgage liens near the back. But every one of them yields to the tax lien first. So the hierarchy is simple. Property tax and special assessment liens come first. Then private liens fall in line earliest to latest. When a question asks which lien is paid first, regardless of recording date, the answer is always the real estate tax lien. Question 39. A construction lender requires the existing lien holder to agree that the new construction loan will take first position. What is this agreement called? Your options are A. An attachment, B. A novation, C. An estoppelcertificaat, D. A subordination agreement. Don't overthink it. Which one feels right? The correct answer is D. A subordination agreement. D is correct because a subordination agreement is a contract in which a senior lien holder voluntarily agrees to let a junior lien move ahead of it. Construction lenders commonly require one, so their new loan takes first position. A is wrong because an attachment is a court's pre-judgment seizure of specific property to secure a possible judgment. It creates a lien through litigation, but it does not rearrange the priority of existing liens by agreement. B is wrong because a novation substitutes a new contract or party for an old one, releasing the original obligation. It replaces agreements rather than reordering lien priority, so it does not describe a lender taking first position. C is wrong because an estoppel certificate confirms the current balance and terms of an existing loan or lease. It verifies facts for a transaction, but does not change which lien holds priority over another. When a construction lender wants to fund a new building, it usually demands first position on the property, but an older lien may already sit on the land. The solution is a subordination agreement, a contract that reorders lien priority by consent instead of by recording date. Normally, first in time means first in right, but a lien holder can voluntarily agree to drop below a newer loan. The senior lender consents to become junior, the junior lender rises to senior, and the recorded agreement locks in the new order. A landowner owed money for the land often benefits when the building actually gets constructed. a finished, income-producing property is far better collateral than empty ground. So subordinating to the construction loan protects the senior lender's own long-term interest. Here's the mechanism. The existing lien holder signs a subordination agreement, voluntarily dropping below the construction loan. Without that signature, the construction lender would remain junior to the older lien and would walk away from the deal. Don't confuse this with similar terms. An attachment is a court's prejudgment seizure. A novation replaces one contractual party with another, and an estoppel certificate just verifies loan balances and terms. Only the subordination agreement reorders lien priority by consent. Question 40. A grantor signs and acknowledges the deed but keeps it locked in a drawer and never hands it over. Has title passed to the grantee? Your options are A. Yes, signing a loan passes title. B. No, delivery and acceptance are required. C. Yes, acknowledgement passes title. D. Yes, once it is recorded. Got a guess? Lock it in. The correct answer is B. No, delivery and acceptance are required. B is correct because title passes only when a deed is delivered with the present intent to convey and accepted by the grantee. A signed deed never delivered conveys nothing, because delivery is the moment ownership actually transfers. A is wrong because signing is a necessary element but does not by itself transfer title. Without delivery to the grantee, the executed deed remains ineffective, so the grantor's signature alone leaves ownership unchanged. C is wrong because acknowledgement before a notary confirms the signature is genuine and allows recording. It does not move title, which still requires the deed to be delivered and accepted before ownership changes hands. D is wrong because recording protects priority against third parties, but is not what transfers title. A deed locked away was never delivered, and recording cannot occur or cure the missing delivery to the grantee. Signing a deed, notarizing it, even recording it, none of these transfer ownership. Title passes only when a deed is delivered with present intent to convey and accepted by the grantee. Delivery means the grantor parts with control of the deed, intending ownership to change hands right now. It's as much about intent as physical handing over. Acceptance means the grantee takes the deed, which the law usually presumes. Together, these two acts complete the transfer. Drafting, signing, and acknowledging are merely preparation. Picture a deed that's been signed and notarized, then locked away in a drawer, never handed to the buyer. Title has not passed because delivery and acceptance never occurred. The deed stays legally inert until the grantor chooses to deliver it. Signing, acknowledgement, and recording each capture something real but insufficient. Signing proves execution but doesn't transfer title without delivery. Acknowledgement confirms the signature is genuine. And recording gives public notice and protects priority. But none of them can move title or cure a missing delivery. A deed transfers ownership only when the grantor delivers it with present intent and the grantee accepts. Signing, notarizing, even readying it for recording all gather around that one act without ever replacing it. Question 41. A buyer wants the strongest possible protection, warranting the title against all defects, even those arising before the seller owned the property. Which deed provides this? Your options are A. A quitclaim deed, B. A bargain and sale deed, C. A general warranty deed, D. A special warranty deed. Which one is it? Pause the video if you need more time. The correct answer is C. A general warranty deed. C is correct because a general warranty deed gives the grantee the greatest protection. Its full set of covenants warrants the title against defects arising at any time, even before the grantor owned the property. A is wrong because A. Quitclaim deed provides the least protection of any deed carrying no covenants. It conveys only whatever interest the grantor may have. so it cannot give the buyer the broad warranty being sought. B is wrong because a bargain and sale deed contains no express warranties. Though it implies the grantor holds title, without binding covenants, it falls short of the full protection a general warranty deed delivers. D is wrong because a special warranty deed warrants only against defects arising during the grantor's own ownership. Because it does not reach problems that predate the grantor, it offers narrower protection than the buyer wants. Deeds range from ironclad to bare bones, and the general warranty deed sits at the very top. It offers the greatest protection any deed can give a buyer, warranting title against defects from any time, even before the grantor owned the property. Its strength comes from 4 covenants: season, against encumbrances, quiet enjoyment, and further assurances. These aren't limited to the grantor's own ownership. They reach backward through the entire chain of title, all the way to the very first owner. Picture the full chain of title stretching back through every past owner. A general warranty deed's coverage reaches all the way back, so if a forged deed or unpaid claim from 3 owners ago surfaces, the grantor is on the hook for it. Other deeds fall short. A quitclaim carries no covenants at all. A bargain and sale deed implies title but has no express warranties. And a special warranty deed protects only against defects during the grantor's own ownership. A special warranty deed is a guarantee with a start date. A general warranty deed has no start date at all. Whenever a buyer wants protection against defects predating the seller, that's the mark of the general warranty deed. Question 42. A title search reveals a misspelled name and an old, possibly invalid mortgage clouding the title. Which deed is typically used to release such doubtful interests? Your options are a quitclaim deed, B, a general warranty deed, C, a special warranty deed, D, an executor's deed. Take a second. Which answer would you pick? The correct answer is A, a quitclaim deed. A is correct because a quitclaim deed conveys only whatever interest the grantor may have, with no warranties. That makes it the standard tool for curing a cloud on title, such as releasing a doubtful claim or correcting a name. B is wrong because a general warranty deed is used to convey ownership with full covenants of title. It is meant for a normal sale, not for releasing a questionable interest that a party may or may not actually hold. C is wrong because a special warranty deed conveys title with limited covenants for the grantor's period of ownership. Like a general warranty deed, it is a conveyance instrument, not the usual device for clearing a recorded cloud. D is wrong because an executor's deed conveys estate property by a personal representative during probate. It addresses transfers from a decedent's estate, not the release of a misspelled name or stale mortgage clouding a chain of title. Sometimes the job isn't selling a property, it's clearing a doubt about who might have a claim to it. A misspelled name in an old deed or a stale, unreleased mortgage can cloud an otherwise good title, and that cloud has to be cured before the property can be sold. A quitclaim deed makes no promises about title. It doesn't warrant that the grantor owns anything, doesn't guarantee the title is clear, and carries none of the covenants a warranty deed provides. It simply releases whatever interest the grantor happens to hold, whether that's full, partial, or nothing at all. Picture a title search turning up a misspelled name on an old deed and a decades-old mortgage that was probably paid off but never formally released. Anyone tied to those records might hold a stray, doubtful interest, and a quitclaim deed from that person releases it cleanly, wiping the cloud from the record without anyone proving whether the interest was ever real. The other deeds are built for conveyance, not cleanup. A general warranty deed conveys ownership with full covenants for a normal sale. A special warranty deed conveys with limited covenants for the grantor's own period of ownership. And an executor's deed transfers estate property through probate. None of them are meant to release a stale, questionable claim. Whenever a question describes clearing a cloud, correcting a misspelled name, or releasing a possibly invalid old claim, the answer is the quitclaim deed, valued precisely because it transfers whatever interest exists and promises nothing about it. Question 43. A general warranty deed includes the grantor's promise that the title will not be disturbed by anyone holding a superior claim. Which covenant is this? Your options are A. Covenant of cession, B. Covenant against encumbrances, C. Covenant of further assurance, D. Covenant of quiet enjoyment. Before I reveal it, which one do you think is right? The correct answer is D. Covenant of quiet enjoyment. D is correct because the covenant of quiet enjoyment is the grantor's warranty that the grantee's title will not be disturbed by someone holding a superior claim. It assures the grantee of peaceful possession against lawful adverse interests. A is wrong because the covenant of cession warrants that the grantor actually owns the property and has the right to convey it. It addresses the grantor's ownership at the time of conveyance, not protection against a later superior claimant. B is wrong because the covenant against encumbrances warrants that no undisclosed liens or easements burden the title. It concerns hidden charges on the property, not the assurance of undisturbed possession against a superior claim. C is wrong because the covenant of further assurance is the grantor's promise to sign any additional documents needed to perfect title. It is about cooperating later, not guaranteeing the grantee against disturbance by a superior claim. A general warranty deed bundles several distinct promises, and each one guards against a different kind of title trouble. One promise protects the buyer's peaceful possession against anyone who later shows up with a better legal claim to the property. That is the exact fear the covenant of quiet enjoyment answers. If someone with a paramount lawful claim disturbs the grantee's possession, the grantor is on the hook. Quiet here doesn't mean silence from noisy neighbors, it means undisturbed by superior legal claims. A general warranty deed carries several covenants and exams test the boundaries between them. Cession warrants ownership at the moment of conveyance. The covenant against encumbrances warrants no undisclosed liens or easements. Further assurance is the promise to sign later documents. Quiet enjoyment alone protects future peaceful possession against a paramount claimant. The real lesson is how these covenants divide the work across time. Cession and the covenant against encumbrances look at the title right now at closing. Further assurance and quiet enjoyment look forward, one to paperwork, the other to possession. So when a grantor promises no superior claimant will ever disturb the grantee's ownership, that is the covenant of quiet enjoyment, the only covenant in the set that looks forward to peaceful possession. Question 44. A person openly, continuously, and without permission occupies another's land for the full statutory period and then sues to claim ownership. This describes which process? Your options are A. Prescriptive easement, B. Voluntary alienation, C. Adverse possession, D. A dedication. What's your answer? Commit to one before I continue. The correct answer is C. Adverse possession. C is correct because adverse possession lets a possessor acquire title by occupying another's land in a way that is open, notorious, exclusive, continuous, and hostile for the statutory period. In Pennsylvania, the general period is 21 years. A is wrong because a prescriptive easement is acquired by similar use but conveys only a right to use, not ownership. The possessor here seeks title to the land, which is the result of adverse possession rather than a mere easement. B is wrong because voluntary alienation is the owner's chosen transfer of title by deed or will. Adverse possession passes title without the owner's consent, so it is involuntary rather than a voluntary conveyance. D is wrong because A, dedication is an owner's gift of land to the public, such as deeding streets to a municipality. It is a voluntary act by the owner, not a claim acquired by an outsider's long, hostile possession. The law can strip title from a rightful owner and hand it to a trespasser, if that owner sleeps on their rights long enough. This doctrine lets someone who occupies another's land the right way for the statutory period acquire legal title to it, and in Pennsylvania that period is 21 years. The occupation must satisfy several strict elements. It must be open and notorious, hostile, actual, exclusive, and continuous for the entire 21-year statutory period in Pennsylvania. Picture someone who openly, continuously, and without permission occupies another's land for the full statutory period, in plain view of anyone who looked, while the true owner never objects. A prescriptive easement grants only a right to use land, not title. Voluntary alienation is an owner's chosen transfer by deed or will, and a dedication is an owner's gift to the public, both voluntary, unlike adverse possession's involuntary loss. Adverse possession is title earned through time and conduct, not a document, turning as much on an owner's failure to act as on a possessor's use. That is why landowners must inspect their boundaries and challenge intruders before the clock runs out. Question 45. A buyer records a properly executed deed in the County Recorder of Deeds office. What legal effect does recording give to the rest of the world? Your options are A. Actual notice, B. Constructive notice, C. Marketable title, D. A title guarantee. Pick one. Trust your gut. Here's your chance to test yourself. The correct answer is B. Constructive notice. B is correct because recording an instrument in the County Recorder of Deeds office gives constructive notice. The law presumes the entire world knows of a properly recorded interest, which protects the recording party's priority against later claimants. A is wrong because actual notice is knowledge a person genuinely has from seeing, reading, or being told something. Recording does not depend on anyone actually reading the record. It charges the world with notice regardless of real knowledge. C is wrong because marketable title is title free of serious defects that a buyer must accept. Recording a deed gives notice of an interest, but it does not by itself guarantee that the title is marketable. D is wrong because recording does not guarantee title or insure against defects. It provides public notice of the recorded interest, while protection against hidden title problems comes from a separate title insurance policy. Recording a document in the public land records does something almost magical. It charges the entire world with knowledge of that document, whether or not anyone ever reads it. This is constructive notice, the engine that makes the recording system work. The law recognizes two kinds of notice. Actual notice is knowledge a person genuinely has. Constructive notice is knowledge the law imputes regardless of actual awareness, because the means of knowing was made public and available. Consider a buyer who records a properly executed deed at the county office. From that moment, everyone is presumed to know of the buyer's interest, and that presumed knowledge protects the buyer's priority against anyone who comes later. Three neighboring ideas get mistaken for constructive notice. Actual notice is real knowledge that recording doesn't require. Marketable title is about title quality, not notice. A title guarantee is protection from an insurer, not the world's presumed knowledge. Recording an instrument gives the rest of the word constructive notice, presumed, worldwide knowledge that protects the recorded interest against every later claimant. Question 46. A buyer wants protection against hidden risks such as a forged deed or an undisclosed heir already in the chain of title. Which product covers these? Your options are A. Home warranty, B. Hazard insurance, C. An appraisal, D. Title insurance. Which would you go with? Lock it in before the reveal. The correct answer is D. Title insurance. D is correct because title insurance is an indemnity policy that, for a one-time premium paid at closing, protects the insured against covered losses from title defects existing before the policy date, including forgery, undisclosed heirs, and recording errors. A is wrong because a home warranty covers the repair or replacement of systems and appliances after closing. It addresses mechanical breakdowns, not defects in the ownership history such as a forged deed or a missing heir. B is wrong because hazard insurance protects against physical loss to the property from fire, storms, and similar perils. It covers damage to the structure, not legal flaws hidden in the chain of title. C is wrong because an appraisal estimates market value for a buyer or lender. It analyzes price and condition and provides no protection at all against hidden defects in the property's ownership history. Some title defects can never be found by searching records. A forged deed decades old, a missing heir, a release recorded against the wrong parcel. Title insurance exists to protect against exactly this hidden category of risk. Title insurance works differently from ordinary insurance. It's paid with a single premium at closing rather than renewed monthly, and it looks backward instead of forward. The insurer agrees to defend the title and pay covered losses if a hidden defect surfaces. The risks covered are exactly the ones a search cannot rule out: a forged deed somewhere back in the chain, an undisclosed heir, a recording error, a document signed by someone lacking capacity, or a lien released against the wrong property. The alternatives protect against entirely different things. A home warranty covers mechanical breakdowns, hazard insurance covers physical damage from fire or storms, and an appraisal just estimates value. None of them look backward at the ownership history the way title insurance does. A buyer worried about a forged deed or an unknown heir buried in the chain needs the one policy that looks backward: title insurance, bought once and standing behind the title for as long as it's owned. Question 47. A lender making a mortgage loan insists on a policy that protects its secured interest in the property as a condition of financing. Which policy is required? Your options are A. A lender's title policy, B. An owner's title policy, C. A home warranty, D. A flood certification. Don't overthink it. Which one feels right? The correct answer is A. A lender's title policy. A is correct because A lenders or mortgagees title policy protects the lender's secured interest and declines as the loan is paid down. Lenders almost always require this policy as a condition of making the loan. B is wrong because an owner's title policy protects the buyer's interest, not the lender's. While a buyer may purchase one, it is the lender's policy that the lender requires to safeguard its own security in the property. C is wrong because a home warranty covers repairs to systems and appliances and has nothing to do with title. It would not satisfy a lender that is insisting on protection for its secured legal interest in the property. D is wrong because a flood certification reports whether a property lies in a special flood hazard area. It addresses flood zone status for insurance purposes, not protection of the lender's title interest in the collateral. Title insurance actually comes in two separate policies, each protecting a different party. Mixing up whose interest each one covers is exactly the trap this topic sets. A lender's policy, also called a mortgagee's policy, protects the lender's secured interest in the property, and lenders almost always require it as a condition of financing. An owner's policy instead protects the buyer's equity. These are two distinct contracts, not interchangeable coverage. A key feature of the lender's policy is that its coverage shrinks as the loan is paid down, since it only protects the outstanding balance, and it disappears once the loan is satisfied. The owner's policy, by contrast, stays fixed at the purchase price for as long as the owner holds the property. This is why a buyer taking out a mortgage often pays for both policies at closing. The lender demands its own coverage, while the buyer separately needs protection for their own equity. The lender's policy does nothing for the buyer's stake. Whenever a lender requires a policy to protect its own secured interest as a condition of the loan, that's the lender's or mortgagee's title policy, full stop. Question 48. In Pennsylvania, the Commonwealth imposes a realty transfer tax on a conveyance, and local taxing bodies usually add their own. Where is the deed itself recorded? Your options are A. The Zoning Hearing Board, B. The State Real Estate Commission, C. The County Recorder of Deeds, D. The Pennsylvania Insurance Department. Got a guess? Lock it in. The correct answer is C. The County Recorder of Deeds. C is correct because in Pennsylvania, deeds and mortgages are recorded with the County Recorder of Deeds, which provides constructive notice. The state realty transfer tax, commonly joined by a local transfer tax, applies to the conveyance. A is wrong because the Zoning Hearing Board hears variance and special exception requests under the municipality's planning code. It handles land use appeals, not the recording of deeds, which belongs to the County Recorder of Deeds. B is wrong because the State Real Estate Commission licenses and regulates real estate licensees. It oversees the profession under licensing law, but it does not record deeds or maintain the county land records. D is wrong because the Pennsylvania Insurance Department regulates title insurance rates and insurers. While related to closings, it does not serve as the office where deeds are recorded for the public record. Every Pennsylvania real estate transfer ends up in one place in the public record, while a separate tax rides along on the transaction itself. Let's untangle who records the deed and who taxes the transfer. The Recorder of Deeds is the county office that receives and preserves recorded real estate instruments. Once a deed is entered into the land records, it gives constructive notice, charging everyone with knowledge of the interest and protecting the recording party's priority against later claims. Picture the deed handed to the County Recorder of Deeds, filed into the land records, and from that moment constructive notice radiates outward, putting the whole world on notice of the interest. The other officers handle different pieces of the system. The Zoning Hearing Board rules on land use appeals, the State Real Estate Commission license agents, and the Insurance Department regulates title insurers. None of them record deeds or keep county land records. Remember, the realty transfer tax, state and local combined, is simply a charge on the conveyance, not a filing office. Wherever that tax appears, the deed itself still goes to the County Recorder of Deeds. Question 49. A break in the recorded succession of owners leaves a gap that prevents establishing clear ownership from the public record. Which action establishes title and clears claims? Your options are A. A partition action, B. An escheat proceeding, C. A subordination agreement, D. A suit to acquire title. Which one is it? Pause the video if you need more time. The correct answer is D. A suit to acquire title. D is correct because when the chain of title cannot be established from the record, an owner may bring a suit to acquire title. This court action establishes ownership and clears competing claims and clouds that impair the title. A is wrong because a partition action ends co-ownership by dividing or selling the property among co-owners. It resolves how shared owners separate their interests, not a gap in the recorded chain of a single title. B is wrong because an escheat proceeding transfers property to the state when an owner dies with no heirs. It applies to ownerless estates, not to clearing a break in the recorded history of an owned parcel. C is wrong because a subordination agreement rearranges lien priority among lenders. It concerns the order of recorded financial claims, not establishing ownership or curing a gap in the chain of title. When the chain of ownership has a gap, the public record alone can't tell us who truly owns the land. Buyers hesitate, lenders refuse, and the only fix is a court action called a suit to quiet title. A suit to quiet title asks a court to examine the evidence, resolve conflicting or doubtful claims, and issue a judgment declaring who actually holds title. The result is a clean title the market can rely on, curing what the record alone could not fix. This remedy fits several situations: a break in the recorded chain of owners, a boundary made uncertain by conflicting descriptions, an old claim that may or may not still be valid, or an adverse possessor confirming title earned through long occupation. In every case, the record alone cannot settle it, so the court decides. Other actions solve different problems. A partition action divides property among co-owners. An escheat proceeding sends property to the state when there are no heirs. And a subordination agreement just reorders lien priority among lenders. None of them cure a gap in the chain of title. Whenever a stem describes a broken chain of ownership or competing claims that must be resolved, the answer is a suit to quiet title, the judicial remedy that clears the clouds the public record left behind. Question 50. A neighbor's newly built garage extends several feet across the boundary onto the adjoining lot. What is this unauthorized physical intrusion called? Your options are A. An easement by necessity, B. An encroachment, C. A license, D. A non-conforming use. Take a second. Which answer would you pick? The correct answer is B. An encroachment. B is correct because an encroachment is an unauthorized intrusion of an improvement, such as a garage, across a boundary onto a neighbor's land. It is usually discovered by survey and can make a title unmarketable if left unaddressed. A is wrong because an easement by necessity is a court-recognized right of access for a landlocked parcel. It is a lawful access right, not the wrongful physical intrusion of a structure across a boundary line. C is wrong because a license is revocable permission to use another's land for a purpose. The garage was not permitted onto the neighbor's lot. It intrudes without authority, which makes it an encroachment rather than a license. D is wrong because a non-conforming use is a land use that lawfully predates a zoning change. It concerns how land may be used under zoning, not a building that physically crosses onto an adjoining owner's property. A neighbor builds a new garage and it turns out the structure extends a few feet across the property line. That physical intrusion has a name, an encroachment. An encroachment is a fixed improvement, a building, fence, driveway, or overhanging roof that crosses a boundary without permission. Unlike a person simply walking across land, this intrusion persists in place, and is typically uncovered only when a survey locates the true boundary line. Picture the garage sitting mostly on its own lot, but a section of it pokes across the boundary onto the neighbor's land. Until a survey pins down the true line, neither party may even realize the structure has crossed it. Don't confuse this with an easement by necessity, a lawful right of access for a landlocked parcel, a license, which is revocable permission that was never granted here, or a non-conforming use, a zoning issue unrelated to a structure crossing a line. A buyer can't be sure whether the structure must be removed or could ripen into a prescriptive right, so the cloud must be resolved through agreement, adjustment, or removal, which is exactly why a careful survey before closing matters so much. That wraps up our practice questions on property ownership and land use. Want more practice? Just click the link in the description to visit our website. There you'll find hundreds of free practice questions and complete in-depth study guides. It's a fantastic resource to sharpen your skills, deepen your understanding, and build the confidence you need for exam day. Hit subscribe so the next video comes straight to you, and good luck on your Pennsylvania real estate salesperson exam.